Corporate fines are a crucial element of the sanctions regime for competition infringements in Australia, just as they are around the world. Criminal penalties for individuals were introduced in 2009, and the first prosecutions have just been launched. However, criminal sanctions are a complement, not a substitute for corporate fines. It's trite to say that corporate fines need to be set at a level conducive to deterrence, as that's the primary objective of enforcement in most, if not all, competition systems. Recently, the OECD conducted an extensive review of Australia's fining system, and it's published a thorough and most thoughtful report. The report makes clear there is a high degree of convergence in the approach taken to fine setting internationally. However, it also makes clear Australia is an outlier, both in the approach that it takes to this and in the relatively low level of resultant fines. Now, there's been a large number of cases, some 95 since 2007, and 2 significant adjustments to the statutory maximum in this country. Yet the level of corporate fines has remained substantially below the statutory maximum over the 44 years in which we've had modern competition law. Penalties have increased over time, it's true, and markedly so over the last decade. So the average corporate fine increased from 1.9 million Australian dollars in 2007 to an average of 8.3 million at the end of 2017. But as many would readily appreciate, these averages fall far below international benchmarks. Indeed, according to the OECD, Australian fines are on average 12.6 times lower than the average fines imposed in the 6 jurisdictions with which it drew comparisons. As the OECD report usefully explains, this gulf in fine levels, it can't be fully accounted for by differences in market size and GDP. It also can't be explained by the fact that in Australia, courts set fines, whereas in other places, administrative agencies do so. A key reason for the relatively low corporate fines in Australia is the method employed in assessing them. The Australian method is unstructured and non-sequential. It's also non-transparent and highly discretionary, and it differs substantially in these respects from the method used in most other jurisdictions. These general observations aside, let me make the following 3 points. First, the Australian method doesn't employ a base amount as a starting point to reflect the economic seriousness of the conduct. It doesn't have an explicit and workable mechanism for ensuring that the fine reflects illegal gains and harms, whereas the international approach is to use the base fine as such a mechanism. It employs measures such as a percentage of value of sales or turnover as a proxy for gains and harms. In Australia, there's an approach known as intuitive synthesis, and under that approach, economic seriousness is just one of the many factors taken into account in penalty assessment, whether aggravating or mitigating. In Australia, there's not explicit weight given to any particular factor or a specific order in which factors are approached. Significantly, it's really not clear how company size and the duration of the conduct are instrumental in terms of assessing an appropriate fine. This approach in Australia also shies away from quantification of any particular factors. Again, contrast that with internationally, where the base fine expressly will reflect company size and conduct duration. And only once the base fine is determined are there then adjustments, generally upwards, having regard to other factors. And some of these factors, like recidivism, are assessed numerically. Secondly, the Australian method uses the statutory maximum as an expression of the seriousness of the conduct in the eyes of the legislature and as a subjective yardstick for assessing the case at hand against the worst possible scenario. While important as general signals to judges, this really doesn't provide much by way of practical guidance in penalty assessment. Certainly, it doesn't necessarily facilitate fines that reflect economic impact. Again, contrast the international method. There, the maximum plays a far more confined and objective role by setting a cap on fines to ensure they don't reach levels that would undermine the policy objective of competitive markets. And thirdly, the Australian system doesn't have published guidelines on the method applied in calculating appropriate penalties, whereas internationally there is specific, and in some cases, prescriptive guidance on such matters. Together with a colleague at the Melbourne Law School, Julie Clark, I've recently published research that documents the Australian record on corporate fines, and we make a series of recommendations to deal with the issues I've referred to. Our recommendations are consistent with those made by the OECD. Here are the key ones. First, the Australian method for assessing corporate fines should be revised to take account of and reflect more closely international experience. And the revised method should incorporate calculation of a base fine for a penalty, using a percentage of affected sales or turnover related to sales that is then multiplied by the duration of the conduct. And secondly, the revised method really should be introduced in guidelines that clearly set out the approach to be taken by the ACCC in assessing appropriate fines. The guidelines should be followed both in negotiating submissions with cooperating parties and for the purposes of submissions in contested matters. Now, admittedly, judicial adoption of a different method may be difficult, having regard to our long-standing adherence to intuitive synthesis. In due course, the difficulty may necessitate legislative amendment to facilitate a change in approach. Adoption of these recommendations would have some significant benefits. It would facilitate an increased level of fines and thereby promote general deterrence. It would ensure that penalties adequately reflect the economic seriousness of the conduct and without adding substantially to the time and cost of litigation. And importantly, it would increase transparency, consistency, and predictability in fine setting, which in turn would promote deterrence. The OECD's report has prompted a robust debate about the level and approach to calculating deterrent fines in this jurisdiction. I commend the report and its recommendations as required reading for all interested in the effectiveness of the Australian enforcement system.